My name is Crystal Jensen, and I would like to talk a little bit about the fundamentals of contract formation. Contracts are an agreement that can be enforced in court, formed by two or more competent parties who agree for consideration to perform or refrain from performing some legal act now or in the future. There are 4 requirements for a valid contract. There must be an agreement, consideration, contractual capacity, and legality. An agreement to form a contract includes an offer and an acceptance. One party must offer to enter into a legal agreement, and another party must accept the terms of the offer. Consideration is any promise made by parties which must be supported by legally sufficient and bargained for consideration. Something of value must be received or promised to convince a person to make a deal. Contractual capacity is where both parties entering into the contract must have the contractual capacity to do so. The law must recognize them as possessing characteristics that qualify them as competent parties. Legality is where the contract's purpose must be to accomplish some goal that is legal and not against public policy. For example, a contract formed for the hired service for someone to commit a robbery or a contract for the selling or purchasing of illegal drugs is not valid. There are 3 types of contracts. They are either bilateral versus unilateral, formal versus informal, and express versus implied contracts. Bilateral versus unilateral. The difference is that in a bilateral, the offeree can accept the offer simply by promising to perform the contract. In a unilateral contract, the offer is phrased so that the offeree can accept only by completing the contract performance. Formal versus informal contracts. In a formal contract, contracts require a special form or method of creation to be enforceable. An example would be a letter of credit, or in the instance of purchasing a car, when a title transfer occurs after the money has been exchanged. Informal contracts include all other contracts where no special form is required except for certain types of contracts that must be in writing. Express versus implied contracts. An express contract, the terms of the agreement are fully and explicitly stated in words, orally or written. An example of this would be a signed lease. An implied contract implies from the conduct of the parties. There are also certain requirements that must be met. Number 1, the plaintiff furnished some service or property. Number 2, the plaintiff expected to be paid for that service or property and the defendant knew or should have known that payment was expected. Number 3, the defendant had a chance to reject the services or property and did not. A common example of this would be a doctor's visit, where if you willingly go to the doctor, you knowingly accept the fact that services will be performed on you and payment will be made at the end of the visit.